President. Article 52 to 78 in Part 5 of the Constitution deals with the Union Executive. The Union Executive consists of the President, the Vice President, the Prime Minister, the Council of Ministers, and the Attorney General of India. The President is the head of the Indian state. He is the first citizen of India and acts as a symbol of the unity, integrity, and solidarity of the nation. Elections of the President. The President is elected not directly by the people but by members of the Electoral College consisting of first, the elected members of both the houses of the Parliament. Second, the elected members of the Legislative Assembly of the states. Third, the elected members of the Legislative Assemblies of the Union Territories of Delhi and Puducherry. This third point was added by the 70 Constitution Amendment Act. Thus, the nominated members of both the houses of the Parliament, the nominated members of the state legislative assemblies, and the members, that is, both elected and nominated of the state legislative councils in case of the bicameral legislature, and the nominated members of the legislative assemblies of the Delhi and Puducherry do not participate in the election of the president. Where an assembly is dissolved, the member cease to be qualified to vote in presidential election, even if fresh elections to the dissolved assembly are not held before the presidential election. The Constitution provides that there shall be uniformity in the scale of representation of different states, as well as parity between the states as a whole and the union at the election of the president. To achieve this, the number of votes which each elected member of the legislative assembly of each state and the parliament is entitled to cast at such election shall be determined in the following manner. First, every elected member of the legislative assembly of a state shall have as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of elected members of the assembly. This can be expressed as, that is, value of vote of an MLA is equal to total population of the state divided by total members of elected members in the state legislative assembly into 1 by 1000. So for example, the total population of the state is 70 lakh, and suppose the total number of elected members of a state legislative assembly is 70,000. Then we will divide and we can then come at the vote of a single MLA. Second point, every elected member of either house of the parliament shall have such a number of votes as may be obtained by dividing the total number of votes assigned to members of the legislative assemblies of the state by a total number of elected members of both the houses of the parliament. This can be expressed as value of vote of an MP is equal to total value of the votes of all the MLAs in all states. Total value of all the votes of all the MLAs in all states divided by the total members of the elected members of elected members of the total number of elected members of the parliament. So the next point, the president's election is held in accordance with the system of proportional representation by means of a single transferable vote, and the voting system is by secret ballot. Voting is by secret ballot. Single transferable vote and by proportional representation. This system ensures that the successful candidate is returned by the absolute majority of the votes. A candidate, in order to be declared elected to the office of the president, must secure a fixed quota of votes. The quota of votes is determined by the dividing the total number of valid votes polled by the number of candidates to be elected. Here only one candidate is to be elected as president plus 1, and adding to the quotient. The formula can be expressed as electoral quota is equal to total number of valid votes polled divided by 1 plus 1, that is 2, is plus 1. So each member of the electoral college is given only one ballot paper. The voter will, while casting his vote, is required to indicate his preference by marking 1, 2, 3, 4, etc. against the number of names of candidates. This means that the voter can indicate as many preferences as there are candidates in the fray. In the first phase, the first preference votes are counted. In case a candidate secured the required quota in the phase, he is declared elected. Otherwise, the process of transfer of votes is set in motion. The ballots of the candidate securing the least number of first preference votes are cancelled, and his second preference votes are transferred to the first preference votes of the other candidates. This process continues till a candidate secures the required quota. All doubts and disputes in the connection with the election of the president are inquired into and decided by the Supreme Court, whose decision is final. Supreme Court, not Election Commission of India, but Supreme Court, whose decision is final. The election of a person as president cannot be challenged on ground that the electoral college was incomplete. That is, existence of any vacancy among the members of electoral college. If the election of a person as president is declared void by Supreme Court, acts done by him before the date of such declaration of the Supreme Court are not invalidated and continue to remain in force. Some members of the Constituent Assembly criticized the system of indirect election of the president as undemocratic and proposed the idea of direct election. However, the constitution makers chose the indirect election due to the following reasons. First, the indirect election of the president is in the harmony of the parliamentary system of the government envisaged in the constitution. Under this system, the president is only a nominal executive and the real powers are vested in the Council of Ministers headed by the Prime Minister. It would have been anomalous to have the president elected directly by the people and not give him any real power. Second, the direct election of the president would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic head. Some members of the Constituent Assembly suggested that the president should be elected by the members of the two houses of the parliament alone. The makers of the constitution did not prefer this, as the parliament, dominated by one political party, would have invariably chosen a candidate from that party, and such a president could not represent the states of the Indian Union. The present system makes the president a representative of the Union and the states equally. Further, it is pointed out in the Constituent Assembly that the expression proportional representation in the case of the presidential election is a misnomer. Proportional representation takes place where two or more seats are to be filled. In case of the president, the vacancy is only one. It could better be called a preferential or alternative vote system. Similarly, the expression single transferable vote was also objected to on the ground that no vote has a single vote, that no voter has a single vote, every voter has a plural vote. So the qualifications, oath and conditions. Qualifications for the election as a president. A person to be eligible for election as president should fulfill the following qualifications. First, he should be a citizen of India. Second, he should be completed 35 years of age. Third, he should be qualified for election as a member of a Lok Sabha. Fourth, he should not hold any office or profit under the union government or any state government or any local authority or any other public authority, a sitting or any other public authority. A sitting president or vice president of the union, the governor of any state, and the minister of the union or any state is not deemed to hold any office of profit and hence qualified as a presidential candidate. Further, the nomination of a candidate for election to the office of the president must be subscribed by at least 50 electors as proposers and 50 electors as seconders. Every candidate has to make a security deposit of 15,000 with the RBI. The security deposit is liable to be forfeited in the case the candidate fails to secure one-sixth of the votes polled. Next point, oath and affirmations of the president. Before entering upon his office, the president has to make and subscribe to an oath or affirmation. In his oath, the president swears first to faithfully execute the office, to preserve, protect, and defend the Constitution and the law, to preserve, protect, and defend the Constitution and the law, to devote himself to the service and well-being of the people of India. The oath of the office of the president is administered by the Chief Justice of India, and in his absence, the senior most judge of the Supreme Court available. Any other person acting as president or discharging the functions of the president also undertakes the similar oath or affirmation. Conditions of president's office. The Constitution lays out the following conditions on the president's office. First, he should not be a member of either house of the parliament or a house of state legislature. If any such person is elected as president, he is deemed to have vacated his seat in that house on the day on which he enters upon his office as president. Second, he should not hold any office of profit. Third, he is entitled, without payment or rent, to the use of his official residence, that is the Rashtrapati Bhavan. Fourth, he is entitled to such emoluments, allowances, and privileges as may be determined by the parliament. Fifth, his emoluments and allowances cannot be diminished during his term of office. In 2008, the parliament increased the salary. Okay. In addition, the former president are entitled to furnish residence, phone facilities, car medical treatment, travel facility, secretarial staff, and office expenses up to rupees 60,000 per annum. The spouse of a deceased president is also entitled to a family pension at the rate of 50% of the pension of a retired president. Furnished residence, phone facility, car medical treatment, travel facility, secretarial staff, and office expenses up to 12,000 per annum. The president is entitled to a number of privileges and immunities. President enjoys personal immunity from legal liability for his official acts. During his term of office, President is immune from any criminal proceedings, even in respect of his personal acts. President cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him during his term of office in respect of his personal acts. So, term, impeachment, and vacancy. So, term of the president's office. The president holds the term of the president's office. The president holds office. The president holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the vice president. Letter to the vice president, that is the chairman of the Rajya Sabha. Further, he can also be removed from the office before completion of his term by the process of impeachment. The president can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of times. However, in USA, a person cannot be elected to the office of the president more than twice. Impeachment of the president. The president can be removed from the office by a process of impeachment for violation of constitution. For impeachment for violation of constitution. For violation of constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. The, the impeachment charges can be initiated by either house of the parliament. These charges should be signed by one-fourth members of the house that framed the charges. One-fourth members of the house that framed the charges, and a 14 days notice should be given to the president. One-fourth member of a house that framed, for example, if Lok Sabha framed the charges, then one-fourth of the members of the Lok Sabha should sign uh, on it. Similarly, in the case of the Rajya Sabha, after the impeachment resolution is passed by a majority of two-thirds of the total membership of the house, two-thirds of the total membership of that house, it is sent to the other house, which should investigate the charges. The president has the right to appear and to be represented at such investigation. If the other house also sustains the charges and passes the impeachment resolution by a majority of two-thirds of the total membership, then the president stands removed from his office from the date on which the bill is so passed. Thus, an impeachment is a quasi-judicial judicial procedure in the parliament. In this context, two things should be noted. A. The nominated members of the either house of the parliament can participate in the impeachment of the president, though they do not participate in his election. And B. The elected members of the legislative assemblies of the states and the UTs of the Delhi and Puducherry do not participate in the impeachment of the president, though they participate in his election. No president has so far been impeached. Vacancy in the presidential office. A vacancy in the president's office can occur in any of the following ways. First, on the expiry of his tenure of 5 years. Second, by his resignation. Third, on his removal by the process of impeachment. Third, by his death. And fifth, otherwise. For example, when he becomes disqualified to hold office or when his election is declared void. So, when the vacancy is going to be caused by the expiration, that is the first point given above. When the vacancy is going to be caused by the expiration of the term of the sitting president, an election to fill the vacancy must be held before the expiration of the term. In case of any delay in conducting the election of the new president by any reason, the outgoing president continues to hold office beyond his term of 5 years until his successor assumes charge. This is provided by the Constitution in order to prevent an interregnum. In this situation, the vice president does not get the opportunity to act as a president or to discharge the functions of the president. This is the only point. That is the on the expiry of his tenure of 5 years. This is the only point in where in which this is the only point. This is the only point in which the term of the president can be extended beyond 5 years, and the vice president does not assume the charge as a president. And in the remaining 4 points, that is from 2 to 5, the term of the president cannot be extended. So, next paragraph: if the office falls vacant by resignation, removal, or death or otherwise, that is points from 2 to 5, then election to fill the vacancy should be within the 6 months from the date of the occurrence of the such vacancy. The newly elected president remains in office for a full term of 5 years from the date he assumes charge of his office. When a vacancy occurs in the office of the president due to his resignation, that is point number 2. Removal, that is point number 3. Death or otherwise, that is point number 4 or 5. The vice president acts as the president until a new president is elected. Further, when the sitting president is unable to discharge his functions due to absence, illness, or any other cause, the vice president discharges his functions until the president resumes his office. In case of the office of vice president is vacant, the CGI or his office is also vacant, the senior most judge of the Supreme Court available acts as a president or discharges the functions of the president. When any person, that is vice president, CGI, or the senior most judge of the Supreme Court is acting as the president or discharging the functions of the president, he enjoys all the powers and immunities of the president and is entitled to such emoluments, allowances, and privileges as are determined by the parliament. Powers and functions of the president. So the powers enjoyed and the functions performed by the president can be the powers enjoyed and the functions performed by the president can be studied under the following heads: executive, legislative, financial, judicial, diplomatic, military, and emergency. So first comes the executive powers. So the executive powers and functions of the president are: A. All executive actions of the government of the India are formally taken in his name. B. He can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. C. He can make rules for more convenient transactions of the business of the union government and for allocation of the said business among the ministers. D. He appoints the Prime Minister and the other ministers. They hold office during his pleasure. E. He appoints the Attorney General of India. He appoints the Attorney General of India and determines his remuneration. President. The AGI holds office during the pleasure of the president. F. President appoints the CAG, the Chief Election Commissioner, the other election commissioners, the chairman and members of the UPSC, the governors of the states, the chairman and the members of the Finance Commission, and so on. The chairman and the members of the Finance Commission. G. He can seek any information relating to the administration of affairs of the Union and proposals of legislation from the Prime Minister. H. President can require the Prime Minister to submit for consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. I. He can appoint a commission to investigate into the conditions of the scheduled caste, scheduled tribe, and other OBCs. J. President can appoint an interstate council to promote the center-state and interstate cooperation. Interstate council under Article 263. K. President directly and administers the union territories through the administrators appointed by him. L. President can declare any area as scheduled area and has the powers with respect to the administration of scheduled areas and tribal areas. Legislative powers. The president is an integral part of the parliament. President is an integral part of the parliament. So the parliament consists of three parts: the president of India, the Lok Sabha, and the Rajya Sabha. So the president is an integral part of Parliament of India and enjoys the following legislative powers. A. He can summon or prorogue the Parliament and dissolve the Lok Sabha. He can also summon a joint sitting of both the houses of the Parliament, which is presided over by the Speaker of the Lok Sabha. So the joint Joint sitting of both the houses of the parliament is presided by the Lok Sabha. B. President can address the parliament at the commencement of the first session after each general election and the first session of each year. C. President can send messages to the House of the Parliament, whether with respect to a bill pending in the Parliament or otherwise. D. President can appoint any member of the Lok Sabha to preside over its proceeding when the offices of both the Speaker and the Deputy Speaker fall vacant. Similarly, President can also appoint any member of the Rajya Sabha to preside over its proceedings when the offices of both the Chairman and the Deputy Chairman fall vacant. E. President nominates 12 members of the Rajya Sabha from among us persons having special knowledge or practical experience in literature, science, art, and social service. F. President can nominate 2 members to the Lok Sabha from the Anglo-Indian community. This point has been done away with. This point has been done away with recently. So I have to find out how, mm, by constitutional amendment act or by simple appropriation bill or budget. G. President decides on question as to disqualification of members of the parliament in consultation with the election commission. H. His prior recommendation or permission is needed to introduce certain types of bills in the parliament. For example, a bill involving expenditure from the consolidated fund of India or a bill for the alteration of boundaries of the states or creation of new states. I. When a bill is sent to the president after it has been passed by the parliament, he can give his assent to the bill or withhold his assent to the bill or return the bill if it is not a money bill for the reconsideration of the parliament. However, if the bill is passed again by the parliament with or without amendments, the president has to give his assent to the bill. J. When a bill passed by the state legislature is reserved by the governor for a consideration of the president can give his assent to the bill, withhold his assent to the bill, or direct the governor to return the bill if it is not a money bill for reconsideration of the state legislature. It should be noted here that it is not obligatory for the president to give his assent even if the bill is again passed by the state legislature and sent again to him for his consideration. K. President can promulgate ordinances when the parliament is not in session. These, these ordinances must be approved by the parliament within 6 weeks from its assembly from its reassembly. He can also withdraw an ordinance at any time. Ordinance under which article? That has to be found. L. President lays the reports of the CAG, UPSC, Finance Commission and others before the Parliament. M. President can make regulations for the peace, progress and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. In the case of Puducherry also, the President can legislate by making regulations but only when the Assembly is suspended or dissolved. Financial powers. The financial powers and functions of the President are: A. Money bills can be introduced in the Parliament only with his prior recommendation. B. He causes to be laid before the Parliament the annual financial statement, that is the Union budget. C. No demand for a grant can be made except on his recommendations. D. He can make advances out of the contingency fund of India to meet any unforeseen expenditure. Contingency. E. President constitutes a finance commission after every 5 years to recommend the distribution of the revenues between the center and the states. The judicial power. The judicial powers of the and the functions of the president are: A. He appoints the chief justice and judges of the Supreme Court and the High Court. Judges of the High Courts are appointed by the president. High courts as well. B. President can seek advice from the Supreme Court on any question of law or fact. However, the advice tendered by the Supreme Court is not binding on the president. C. President can grant pardon, reprieve, respite, and remission of punishment or suspend, remit, or commute the sentence of any person convicted, convicted of any offense. In all the cases where the punishment or sentence is by the court martial, in all the cases where the punishment or sentence is for the offense against the Union law, and in all the cases where the sentence is a sentence of a death. Diplomatic powers. The international treaties and agreements are negotiated and concluded on behalf of the president. However, they are subject to the approval by the parliament. They are subject to the approval of the parliament. President represents India in international forums and affairs and sends and receives diplomats like ambassadors, high commissioners, and so on. Military powers. President is the supreme commander of the defense forces of India In that capacity, he appoints the chief of the army, navy, and the air force. President can declare war or conclude peace, subject to approval of the parliament. Subject to the approval of the parliament. Emergency powers. In addition to the normal powers mentioned above, the Constitution confers extraordinary powers on the President to deal with the following three types of emergencies: A. National emergency under Article 352. B. President's rule under Article 356 and 365. And C. Financial emergency under Article 360. So next comes the veto power of the President. A bill passed by the Parliament can become an act only if it receives the assent of the President. When such a bill is presented to the President for his assent, he has three alternatives under Article 111 of the Constitution. Under Article 111, 111 of the Constitution, he may either give his assent to the bill, he may withhold his assent to the bill, or President may return the bill if it is not a money bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President, the President must give his assent to the bill. Thus, the President has the veto power over the bills passed by the Parliament. That is, he can withhold his assent to the bill. The object of conferring this power of the President is twofold. A. To prevent hasty and ill-considered legislation by the Parliament, and B. To prevent a legislation which may be unconstitutional. The veto power enjoyed by the executive in modern states can be classified into the four types: absolute veto, qualified veto, suspensive veto, and pocket veto. So first is the absolute veto, that is withholding of assent to the bill passed by the Parliament. Then second comes the qualified veto, which can be overridden by the legislature with a higher majority. 3. Suspensive veto, which can be overridden by the legislature with an ordinary majority. And fourth, pocket veto, that is taking no action on the bill passed by the legislature. Of the above four, the President of India is vested with absolute, suspensive, and pocket veto. President of India does not have qualified veto. There is no qualified veto in the case of Indian President. It is possessed by the, that is, qualified veto is possessed by the American President. Absolute, pocket, and suspensive vetoes. So absolute veto, it refers to the power of the President to withhold his assent to a bill passed by the Parliament. The bill that ends and does not become an act. The bill then ends and does not become an act. Usually, this veto is exercised in the following two cases: with respect to the private member's bill, that is, bills introduced by any members of the Parliament who is not a minister, and with respect to the government bills, when the cabinet resigns. With respect to the government bills, when the cabinet resigns after the passage of the bill, but before the assent of the President. And the new cabinet advises the President not to give his assent to such bill. In 1954, President Dr. Rajendra Prasad withheld his assent to the PEPSU appropriation bill. The bill was passed by the Parliament when the President's rule was in operation in the states of the PEPSU. But when the bill was presented to the President for his assent, the President's rule was revoked. Again in 1991, President R. Venkataraman withheld his assent to the salary, allowances, and pension of the members of the Parliament Amendment Bill. The bill was passed by the Parliament on the last day before the dissolution of the Lok Sabha without obtaining the previous recommendation of the President. Now the next point is the suspensive veto. The President exercises this veto when he returns. The President exercises suspensive veto when he returns a bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendment, and again presented to the President, it is obligatory for the President to give his assent to the bill. This means that the presidential veto is overridden by a repassage of the bill by the same ordinary majority and not a higher majority as required in the USA. As mentioned earlier, the President does not possess this veto in the case of the money bills. The President can either give his assent to a money bill or withhold his assent to a money bill, but cannot return it for the reconsideration of the Parliament. Withhold. President can withhold the money assent to the money bill. Normally, the President gives his assent to the money bill as it is introduced in the Parliament with his previous permission. So the next is the pocket veto. In this case, the president neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for an indefinite period. This power of the president not to take any action that is either positive or negative on the bill is known as the pocket veto. The president can exercise this veto power as the constitution does not prescribe any time limit within which he has to take the decision with respect to the to a bill presented to him for his assent. In USA, on the other hand, the president has to return the bill for reconsideration within 10 days. Hence, it is remarked that the pocket of the Indian president is bigger than that of the American president. In 1986, President Zail Singh exercised the pocket veto with respect to the Indian Post Office Amendment Bill. The bill passed by the Rajiv Gandhi government imposed restrictions on the freedom of the press and hence was widely criticized. After 3 years in 1989, the next president R. Venkataraman sent the bill back for reconsideration, but the new National Front government decided to drop the bill. It should be noted here that the president has no veto power in respect of a constitutional amendment bill. No veto power in respect of constitutional amendment bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the president to give his assent to the constitutional amendment bill. The 24th Amendment Bill, the 24th CA made it obligatory for the president. देना ही पड़ेगा भाई. 1971 Presidential veto over state legislature. The president has veto power with respect to a state legislature also. A bill passed by a state legislature can become an act only if it receives the assent of the governor or the president. In case the bill is reserved for the consideration of the president. So, when a bill passed by the state legislature is presented to the governor for his assent, he has four alternatives under Article 200 of the Constitution. Under Article 200 of the Constitution, and in case of the Parliament, it is under Article 111. So, under Article 200 of the Constitution, President, Governor. This is the case of the Governor. Governor under Article 200 and President below under Article 201. So, Governor under Article 200. Governor may give his assent to the bill. Governor may withhold his assent to the bill. Governor may return the bill if it is not a money bill for reconsideration of the state legislature. Governor may reserve the bill for the consideration of the president. When a bill is reserved for the governor by the governor for the reconsideration of the president has three alternatives under Article 201 of the Constitution. President may give his assent to the bill. President may withhold his assent to the bill. President may direct the governor to return the bill if it is not a money bill for the reconsideration of the state legislature. If the bill is passed again by the state legislature with or without amendments and presented again to the president for his assent, the president is not bound to give his assent to the bill. This means that the state legislature cannot override the veto power of the president. Further, the Constitution has not prescribed any time limit within which the president has to take a decision with regard to the bill reserved by the governor for his consideration. Hence, the president can exercise pocket veto in respect of the state legislature also. So, table 17.2 veto powers of the president at a glance in case of central legislature and in case of state legislature. So, with regard to ordinary bills, can be ratified, can be ratified. Second point, can be rejected, can be rejected. Third, can be returned, can be returned. So, ordinary bills can be ratified, can be rejected, and can be returned both in case of legislation and state legislature, and both in case of central and state legislature. So, with regard to veto power of the president with regard to money bills. So, money bills can be ratified, can be rejected. Can be ratified, can be ratified. In this both in the state and central legislature. Can be rejected but cannot be returned. Can be rejected but cannot be returned in both the cases. And with regard to constitutional amendment bills, can only be ratified. That is, cannot in case of central legislation, president can only be ratified constitutional amendments. That is, it cannot be rejected or returned. In case of state legislature, constitutional amendment bills cannot be introduced in the state legislatures. This is an important point, that the constitutional amendment bills cannot be introduced in the state legislature. Constitutional amendment bills can only be introduced in the parliament. So the next point, ordinance making power of the president under Article 123. So the Cooper case and the DC Wadhwa case are associated with the ordinance making power of the president. So under Article 123, Article 123 of the Constitution, Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of the Parliament. These ordinances have the same force and effect as an act of the Parliament, but are in the nature of temporary laws. The ordinance making power is the most important legislative power of the President. It has been vested in him to deal with unforeseen or urgent matters. But the exercise of this power is subject to the following four limitations. First, he can promulgate an ordinance only when both the houses of the Parliament are not in session or when either of the two houses of the Parliament is not in the session. An ordinance can also be issued when only one house is in session, because a law can be passed by both houses and not by one house alone. An ordinance made when both the houses are in session is void. Thus, the power of the President to legislate by ordinance is not a parallel power of the legislation. Second, President can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. In Cooper case in 1970, the Supreme Court held that the President's satisfaction can be questioned in a court on the ground of mala fide, M-A-L-A-F-I-D-E, mala fide. This means that the decision of the President to issue an ordinance can be questioned in a court on the ground that the President has prorogued one house or both houses of the Parliament deliberately with a view to promulgate an ordinance on a controversial subject so as to bypass the parliamentary decision and thereby circumventing the authority of the Parliament. The 30th Constitutional Amendment Act of 1975 made the President's satisfaction final and conclusive and beyond judicial review, but this provision was deleted by 44th Constitutional Amendment Act of 1978. Thus, the President's satisfaction is justiciable on the ground of mala fide. Third point, President ordinance making power is coextensive as regard is coextensive is coextensive as regards all matters except duration with the law making powers of the Parliament. This has two implications. A. An ordinance can be issued only on those subjects on which the Parliament can make laws, and B. An ordinance is subject to the same constitutional limitations as an act of the Parliament. Hence, an ordinance cannot abridge or take away any of the fundamental rights. So, the fourth point. Every ordinance issued by the President during the recess of the Parliament must be laid before both the houses of the Parliament within when it resembles. If the ordinance is approved by both the houses of the Parliament, it becomes an act. If Parliament takes no action at all, the ordinance ceases to operate on the expiry of the 6 weeks from the reassembly. 6 weeks from the reassembly of the Parliament. The ordinance may also cease to operate even earlier than the prescribed 6 weeks if both the houses of the Parliament pass resolutions disapproving it. Both if the houses of the Parliament are summoned to reassemble on different dates, the period of 6 weeks is calculated from the later of those dates. This means that the maximum life of an ordinance can be 6 months and 6 weeks in case of non approval by the Parliament, 6 months being the maximum gap between the two sessions of the Parliament. If an ordinance is allowed to lapse without being placed before the Parliament, then the acts done and completed under it before it ceases to operate remain fully valid and effective. The President can also withdraw an ordinance at any time. However, this power of ordinance making is not a discretionary power, and he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Prime Minister. An ordinance, like any other legislation, can be retrospective, that is, it may come into force from a backdate. It may modify or repeal any act of the Parliament or another ordinance. It can alter or amend the tax law also. Tax law also. However, it cannot be issued to amend the Constitution. An ordinance cannot be issued to amend the Constitution. The ordinance making power of the President in India is rather unusual and not found in most of the democratic constitutions of the world, including that of the USA and UK. In justification of the ordinance making power of the President, Dr. B.R. Ambedkar said in the Constitutional Assembly that the mechanism of issuing an ordinance has been devised in order to enable the executive to deal with a situation that may have suddenly and immediately arise when the Parliament is not in session. It must be clarified here that the ordinance making power of the President has no necessary connection with the national emergency envisaged in Article 352. Article 352. The president can issue an ordinance even when there is no war or external aggression or armed rebellion. Armed rebellion. The rules of Lok Sabha require that whenever a bill seeking to replace an ordinance is introduced in the House, a statement explaining the circumstances that had necessitated immediate legislation by ordinance should also be placed before the House. So far, no case has gone to the Supreme Court regarding re-promulgation of ordinance by the President. But the judgment of Supreme Court in the DC Vadhva case in 1987 is highly relevant here. In this case, the court pointed out that between the 1967 and 1981, the governor of Bihar promulgated 256 ordinances, and all these were kept in force for periods ranging from 1 to 14 years by promulgating from time to time. The court ruled that the successive promulgation of ordinances with the same text without any attempt to get the bills passed by the assembly would amount to violation of the constitution, and the ordinance so promulgated is liable to be struck down. It held that the exceptional power of lawmaking through ordinance cannot be used as a substitute for the legislative power of the state legislature. So next comes the pardoning power of the president. Under Article 72 of the Constitution empowers the president. Article 72 empowers the president to grant pardons to persons who have been tried and convicted of any offense in all cases where the punishment or sentence is for an offense against a union or a union law against a union law where the punishment or sentence is by a where the punishment or sentence is by a court martial, that is in the military court, and sentence is a sentence of death. The pardoning power of the president is independent of the judiciary. It is an executive power. So the pardoning power of the president is independent of judiciary and is an executive power. But the president, while exercising this power, does not sit as a court of appeal. The object of conferring this power on the president is twofold. First, to keep the door open for correcting any judicial errors in the operation of the law, and B, to afford relief from a sentence which the president regards as unduly harsh. The pardoning power of the president includes the following. First, the pardon. Pardon removes both the sentences and the conviction, and completely absolves the convict from all sentences, punishments, and disqualifications. Commutation. Commutation denotes the substitution of one form of president from a later form. For example, a death sentence may be commuted to rigorous imprisonment, which may in turn be commuted to a simple imprisonment. Third, remission. Remission implies reducing the period of sentence without changing its character. For example, a sentence of rigorous imprisonment of 2 years may be remitted to rigorous imprisonment for 1 year. Respite denotes awarding a lesser sentence in place of one originally awarded due to some special fact such as physical disability of a convict or pregnancy of a woman offender. 5. Reprieve. Reprieve implies a stay of the execution of a sentence, especially that of death, for a temporary period. Its purpose is to enable the convict to have time to seek pardon or commutation from the president. Under Article 161 of the Constitution, the governor of a state also possesses the pardoning power. However, the governor can also grant pardons, reprieve, respite, and remissions of punishment, or suspend, remit, or commute the sentences of any persons convicted of any offense against of a state law. But the pardoning power of the governor differs from that of the president in the following respects. The president can pardon sentence inflicted by the court martial, that is military courts, while the governor cannot. And second, the president can pardon death sentence while the governor cannot. Even if a state law prescribes death sentence, the power to grant pardon lies with the president and not the governor. However, the governor can suspend, remit, or commute that. However, the governor cannot pardon a death sentence, but governor can suspend a death sentence. Governor can remit a death sentence, or governor can commute a death sentence. In other words, both the governor and the president have concurrent power in respect of suspension, remission, and commutation of death sentence. The Supreme Court examined the pardoning power of the president under different cases and laid down the following principles. First, the petitioner for mercy has no right to an oral hearing by the president. Second, the president can examine the evidence afresh and take a view different from the view taken by the court. Third, the power is and the power is to be exercised by the President on the advice of the Union Cabinet. Union Cabinet. Fourth, the President is not bound to give reasons for his orders. Fifth, the President can afford a relief not only from a sentence that he regards as unduly harsh but also from an evident mistake. Sixth, there is no need for the Supreme Court to lay down specific guidelines for the exercise of the power of the power by the President. 7. The exercise of the power by the President is not subject to judicial review except where the presidential decision is arbitrary, irrational, malified, or discriminatory. 8th. Where the earlier petition for mercy has been rejected by the President, stay cannot be obtained by filing another petition. Constitutional position of the President. The Constitution of India has provided for the parliamentary form of government. Consequently, the President has been made only a nominal executive, the real executive being the Council of Ministers headed by the Prime Minister. In other words, the President has to exercise his powers and functions with the aid and advice of the Council of Ministers headed by the Prime Minister. Dr. B.R. Ambedkar summed up the true summed Dr. B.R. Ambedkar summed up the true position of the President in the following way. So Dr. B.R. Ambedkar said, in the case of Indian Constitution, there is a place at the head of the Indian Union, a functionary who is called the President of the Union. The title of the functionary reminds of the President of the United States, but beyond the identity of names, there is nothing in the common between the form of the government prevalent in America and the form of the government adopted under the Indian Constitution. The American form of government is called the presidential system of government, and what the Indian government and what the Indian Constitution adopted is a parliamentary system. Under the presidential system of America, the president is the chief head of the executive and administration is vested in him. Under the Indian Constitution, the president occupies the same position as the king under the English Constitution. President is the head of the state but is not of the executive. President represents the nation but does not rule the nation. He is the symbol of a nation. His place in administration is that of a ceremonial device or a seal by which the nation's decisions are made known. He is generally bound by the advice of his ministers. He can do nothing contrary to their advice, nor can he do anything without their advice. The President of the US can dismiss any secretary at any time. The President of the Indian Union has no power to do so, so long as his ministers command a majority in the parliament. So long as his ministers command a majority in the parliament. In estimating the constitutional position of the President, particular reference has to be made to the provision of the Article 53, 74, and 75. These are: first is related with Article 53. The executive power of the Union shall be vested in the President and shall be exercised by him either directly or through offices subordinate to him in accordance with this Constitution. Second, under Article 74, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. Article 75. The Council of Ministers shall be collectively responsible to the Lok Sabha. This provision is the foundation of the parliamentary system of the government. The 42nd Constitutional Amendment Act of 1976 made the President bound by the advice of the Council of Ministers headed by the Prime Minister. The 44th Constitutional Amendment Act of 1978 J. Morarji Desai government authorized the President to require the Council of Ministers to reconsider such advice either generally or otherwise. However, he shall act in accordance with the advice standard after such reconsideration. In other words, the President may return a matter once for reconsideration of his minister, but the reconsidered advice shall be binding. In October 1997, the Cabinet recommended President K.R. Narayanan to impose President rule in UP under Article 356. The President returned the matter for the reconsideration of the Cabinet, which then decided not to move ahead in the matter. Hence, the BJP-led government under the Kalyan Singh was saved. Again, in September 1998, the President K.R. Narayanan returned a recommendation of the Cabinet that sought the imposition of the President rule in Bihar. After a couple of months, the Cabinet re-advised the same. It was only then that the President's rule was imposed in Bihar in February 1999. Though the President has no constitutional discretion, he has some situational discretion. Some situational discretion. President has no constitutional discretion. President has no constitutional discretion but some situational discretion. In other words, the president can act on his discretion, that is, without the advice of the ministers, under the following situations. First, appointment of the Prime Minister. When no party has a clear majority in the Lok Sabha or when the Prime Minister in office dies suddenly and there is no obvious successor. Second, dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. Third, dissolution of the Lok Sabha if the Council of Ministers has lost its majority. So the article number 52 deals with the President of India, 53 deals with the executive power of the Union, 54 deals with the election of the President, and 55 deals with the matter of the election of the President. 56 deal with the term of the office of the President, 57 eligibility for re-election, 58 Article 58 qualifications for election as President, 59 conditions of President's office, 60 oath and or affirmation of the oath or affirmation by the President, 61 procedure for impeachment of the President, 62 time for holding election to fill vacancy in the office of President, Article 65 Vice President to act as the President or to discharge his functions, Article 74 Council of Ministers to aid and advise the President, Article 74 Council of Ministers to aid and advise the President, Article 65 VP to act as PP or to charge his functions, 75 other provisions as to ministers like like appointment terms and salaries, etc. 76 AGI, 111 assent to bills passed by the Parliament, 112 Union Budget that is annual financial statement, 123 power of the President to promulgate ordinances, 143 power of the President to consult Supreme Court, 143 power of the President to consult Supreme Court. However, the advice tendered by the Supreme Court under Article 143 to the President is not